Judgment pertaining to forbearance, item number 1.
For the reasons mentioned in the judgment, this court is of considered opinion that though the petitioners are under statutory mandate of acquiring the requisite minimum educational qualification as prescribed by National Teachers Education Council, however, they have to do so within the extended time frame in pursuant to the notification dated 15/9/2021, compelling the petitioner to produce the educational documents prior to lapse of the extended period would be contrary to the notification dated 15/9/2021. Hence, the improved notifications are hereby set aside. And this writ petition is accordingly disposed of.
Delivery of judgment, item number 1 and 2.
In item number 1, for reasons mentioned in the judgment, this criminal revision petition is dismissed. Sorry, criminal appeal is dismissed. Sorry, criminal revision petition is dismissed. The petitioner is directed to appear before the trial court within 1 month from the date of this judgment to serve out the sentence imposed by the trial court. In item number 2, for reasons stated in the judgment, the revision petition is dismissed.
Item 51 from supplementary list.
For reasons stated in the judgment, the transfer petition is dismissed. However, it is directed that when the petitioner is required to personally visit the trial court in connection with FC civil case number 1145/2025, the respondent shall have to pay the expenses borne by her for her travel as fixed by the trial court in this regard.
Mention effect.
May I please? I pray for listing of a FAO on Wednesday also.
Senior court is there.
No, FAO is interested this court. FAO.
Yes. When?
Wednesday.
Okay.
May please, Your Lordship. Similar connected appeal, Your Lordship. Wednesday, Your Lordship. FAO.
What stage?
No, my injunction application is dismissed on the very first date without issuing notice.
Okay. Okay.
May I please, Your Lordship, with the consent of the other side, I beg to mention item number 28, 29, 30, and 32 for the medical urgency of engaged counsel, Your Honor.
You have informed the other side?
Yes, Lordship.
What
The
is-
other side is present here.
What is your name?
N. Burman for A. Bhattacharya.
Heard Mr. N. Burman, learned counsel, appearing on behalf of Mr. A. Bhattacharya, learned counsel for the appellant, who prays for an adjournment on the ground of medical urgency. On the medical ground. Stop. Learned, who is for the other side?
I'm
He,
appearing on behalf of the respondent number 4, my lordship.
what is your name?
PS Raja.
PS,
Raja.
be louder.
PS Raja, my lordship. PS
PS.
Raja.
P. Learned counsel for the respondent, Mr. P.S. Raja, does not raise any objection to the said prayer. Hence, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Obliged, lordship.
May I please, your lordship? I wish to mention for listing one IA file in FAO, my lord. On Wednesday or Friday, my lord.
What I,
IA for staying the input order, my lord.
okay. Friday.
All right.
May I please, your lordship? Lordship, I beg to mention item number 34. Matter will be adjourned for the day.
Why?
Lordship, my senior is out of town.
Have you informed the other side?
Lordship, confirmation taken.
What is your name?
S. Sekia on behalf of S. Count.
Heard Miss S. Saikya appearing on behalf of Miss S. Count, learned counsel for the applicant slash appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petition for the applicant.
Lordship, I'm for respondent number 2. I'm appearing on behalf of Dina.
What is your name?
R. Sahana.
R.
Sahana. R. Sahana. I'll write it.
Write your name. Learned counsel for the respondent does not raise any objection, hence the prayer is allowed. Let this matter be listed on 13th of March.
Next.
May I please, your lordship? Lordship, I beg to mention MEC 416, public 20, record listing on 18 February, lordship.
MSc senior court is there.
No, sir. This one also senior lordship. No,
Okay. Why?
lordship, at first I sent 3-time notice to insurance company, but service was not clear. After 5 months ago, Mr. T. Kulita filed Okolatnama on 24/10/25.
On Wednesday.
Okay, lordship. Obliged.
Lordship, may I please, lordship? I beg to mention one FAO to be listed tomorrow, lordship.
Why?
Your lordship, matter is such, your lordship, that the respondents herein are trying to conduct the second phase of handing over, lordship, on 18th, unanimously, your lordship. And
Handing over of what?
Lordship, handing over of possession of flats, lordship. Because I am one of the partner of the builder, your lordship. So I am not being allowed to participate in the handing over position. So this is of most urgent. We have approached the London trial court. Only issues no so-called notice has been issued, lordship. So this is of very urgent nature, lordship.
What urgency?
Lordship, because I have not been allowed to participate in the event, lordship.
What happens? Then what happens?
No, because lordship, they have been acting unanimously because there was a settlement agreement also, lordship, that has not been yet been given effect to by the respondents. Behind the back of the petitioner.
You have sought for injunction.
Yes, lordship. That has not been allowed. So only so notice has been issued.
Okay, tomorrow.
Obliged,
My please, your lordship, I beg to mention item number 9 for adjournment, lordship, as per instruction of the.
Why?
client.
Why?
So, lordship, this is the transit way, lordship.
No, why you are seeking for adjournment?
As per the instruction of the client, your lordship, there are difficulties to.
What is your name?
Islam, lordship.
Heard Mr. A. Islam, learned counsel for the petitioner who seeks an adjournment. The prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
May please, your lordship, I beg to
Yes.
mention item 14, my lord. Others party consent here, my lord, 2 weeks time given.
What is your name?
Miss DJ Bora,
For appellant or respondent?
appellant. Appellant side, my lord.
You are sure?
Your
Heard Miss DJ Bora, learned counsel for the appellant who seeks an adjournment on the ground of personal difficulty. She submits that she has informed learned counsel for the respondent who does not have any objection to the prayer. Hence, the prayer is allowed. Let this matter be listed
That may be fixed.
on 13th of March.
Bless me.
May please your lordship. I beg to mention item number 6. In this, here we have to, we want to file one affidavit in this bail application. Because we have not annexed the order passed by this honorable court. Therefore, let matter be fixed on Friday.
Heard Miss
D. Goswami.
D. Goswami, learned counsel for the petitioner, who seeks an adjournment to enable the petitioner to bring on record certain relevant documents necessary for consideration of the instant anticipatory bail application. The prayer is allowed. Let this matter be listed on Friday, 20 February.
Item 3.
May I please your lordship. Second bill application, my lord. Earlier order, my lord. Page number 31.
NDPS,
LDPS.
pending trial.
Pending trial, my lord.
What is the ground?
My lord, this present petitioner has been arrested merely on statement of co-accused. Nothing has been recovered from this further.
This was not considered on earlier occasion.
Not earlier occasion, my lord, during pendency of this case, such has been submitted. Therefore, this honorable court directed to approach the learned court below.
Okay, we'll call for the
Lordship.
records. Heard Mr. H.A. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Let the scanned copy of the trial court records along with scanned copy of the connected case diary be called for the registry to take steps for requisitioning the scanned copy. Let this matter be listed on 18th of March.
For also same affair, my lord, same case.
For same order.
All right.
Item 5.
The charge sheet is filed by. TCR will be called for.
No, they have to show the grounds first.
What is the ground?
Ground, my lord, kindly see this.
No, you tell me the ground. On what ground you are seeking?
My lord, notice under section 47 and 48 is not as per the procedure, my lord. Not served as per the procedure.
Okay. Heard Mr. H.R. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Call for the scanned copy of the trial court records along with the connected scanned copy of the connected case diary. The registry to take steps for requisitioning the scanned copy. Let this matter be listed on 18th of March.
Right.
Item 7.
May I please your lordship? My lord, this is the second time bail application, my lord. My lord, the ground has been taken that at the first instance, my lord, 4 numbers of witnesses were examined and the bail was
Oxo.
taken at the, my lord, it is NDPS, my lord, commercial quantity, my lord. And now, my lord, 7 numbers of witnesses has been examined, my lord.
No, how it helps you?
Yes.
Number of witnesses examined in a NDPS matter where 37 embargo is
My
there.
lord, in that witnesses, my lord, some loopholes has been come that there is a chance that the accused person may be acquitted, my lord.
This is not sufficient. Yes, Mr. Sharma.
Lordship, I have objection in that regard, Lordship, because number of witnesses, there may be discrepancy here and there, Lordship, but based on one witness also, conviction can be granted. And
No,
Lordship,
on what ground you are seeking bail?
My lord, the length of detention is one and the numbers of
What is the
witnesses has been
length?
already been examined, my
for
lord.
2025.
Out of 12 witnesses, my lord, 7 numbers of witnesses has been examined.
No. Suppose 7 numbers of witnesses have been examined. How it is going to help you?
Lord, the informant has been examined and there are many lacunas has been come out in favor of the accused. My lord. So, my lord, at this stage, my lord, PCR may be called.
Lordship may
No. You first make out a case, otherwise we'll dismiss it at this stage. You make out a case so that court feels it necessary to peruse the trial court
If you
record.
fix on 19, my lord, I will argue on that.
I am dismissing it.
Give me 2
You
days.
you have come to the court without preparing your case.
Well,
You have
generally-
taken it for granted that by mere filing a bail application, why you are not prepared now?
Lord. In this case, my lord, if we go to the facts, my lord, and the two.
Come
two points, my
prepared
lord,
on
two
19.
grounds that in the.
Let him come prepared. Come prepared on 19. On request of learned counsel for the petitioner, Mr. A.K. Azad, let this matter be listed again on 19th of March, 19th of February.
Obligation. That is the same, my lord, the co-accused.
Here also you are not prepared.
That's the same FIR, my lord.
Same order.
Obligation.
My item number 10 can be after some time. I have informed he is coming, my lord.
also
He was selected in court number 14.
also I have detailed another court, Lordship. On a
He's
2
coming,
of
I have informed him, my lord. Sorry, my lord, I don't have the brief also. He's coming. Just no.
Item number
10, my
10.
lord. I have informed he's coming, my lord. Maybe on the first floor, my lord.
Who is coming from where he is coming?
My lord, I'm sorry, my lord. Mr. A. Chaudhary. I have informed he's coming, my lord.
Okay, Lordship. 10 minutes. He stated 10 minutes also.
Okay, we'll wait for some
I'm
time.
sorry, my lord.
For reference to the special mediation trial, item 11.
Well, I prefer 1 week time, my lord. I have to go to the files. My lord, so little, my lord.
Seek instructions.
Yes. Okay, instruction. my lord.
I am for experiment 3, my lord.
You have any objection?
Experiment number 3, my
No, you have any objection in referring the matter to,
lord.
I am appearing on behalf of respondent number 1 and 2.
you have any objection?
My lord, I have to seek instruction. my lord. 1 week
What
time.
is your name?
VK Borwa, my lord.
Or Mr. V.K. Borwa, learned counsel for the appellant. Also Miss
J. Parker,
J. Sarkar appearing for respondent number
3.
3, as well as Miss
ALR Yanthan. ALR Yanthan.
A.L.R. Yangthang appearing for respondent number
1 and 2.
1 and 2. Though learned counsel for the respondent does not have any objection in referring this matter to the mediation under special drive of mediation for nation. However, learned counsel for the appellant prays for 1 week's time for seeking necessary instructions in this regard from the appellant. The prayer is allowed. Let this matter be listed again on 27th of February.
Earlier, my lord.
Item 12 and 13.
Parents, my lord, died in accident, my lord. Parents, both mother and father.
Whether this can be referred to mediation.
Possibly not, my lord.
Why?
Because loved one is there, my lord.
Yes,
Because
Ms.
it is-
Majumdar. You have it.
Lordship, it is his appeal.
You
So
have any objection?
I do not have any objection because it is, I think it is in quantum only.
Yes, quantum only.
Quantum cases can be referred, Lordship. They are fit cases.
Let us,
One chance, my lord. Then your lordship refer.
one chance means you want to take instructions.
No, my lord, no.
Huh.
Refer the matter before the,
But then the claimants have to appear, Lordship.
oh,
That he have.
he's a doctor now, it is.
Where he's staying.
My lord, Calcutta, my lord.
In mediation, can the appearance may be through video conferencing?
Oh.
Let us see. Let us refer. Heard Mr. H. Das, learned counsel for the appellant. Also heard Ms. R.D. Majumdar appearing for respondent number 3, as well as Mr.
And Burman,
N. Burman appearing for
respondent 1.
respondent number 1. Any other counsel?
May
May I please, your lordship? I'm for the respondent number 3, lordship.
I'm for 2 lodge. No, in, I am shown as 3.
In item number 12, lordship, I am for the respondent number 3.
What is your name?
Not my respondent number.
What is your name?
P. Deka. lordship.
Also, Mr.
In item number
P.
12.
Deka appearing for respondent number 3 in MSC case number 48/2020. Since both the motor accident, both the MSC appeals are filed seeking enhancement of compensation awarded to the claimant. And since learned counsel for both the sides have submitted that this is a fit case which may be referred to mediation, this case is referred to mediation. The parties are directed to appear before the appointed mediator before the mediator appointed by the High Court Mediation Center on when they gets notice from the High Court Mediation Center. Let this matter be listed again after 3 months at the date.
11th of May.
On 11th of May for report of the mediator.
Item 15.
Can it be referred?
It is not a fit case, I think.
Why?
Because here the issue raised by my friend, and we have also filed a cross objection. And
No,
This is for what?
no, lordship, we have filed the appeal, insurance company.
Here you are the appellant.
Yes,
Okay.
they are in the cross objection. Lordship, in the meantime, the injured has died. So the parents are made legal heirs. And they have filed the cross objection. Can the parents file a cross objection in the injury case, not a death case? So that legal point is there. But otherwise, on quantum
after the judgment of the tribunal lordship, the injured died. After that.
No, the question is if whether this question has been raised by you in the
Their cross objection is now, lordship.
cross objection is for
We are challenging the involvement of the vehicle itself, lordship, in the accident.
No, is it a fit case?
No, lordship, because of those points, lordship. Because we are alleging fraud in the case.
Heard Mr. M. Khan, counsel for the respondent in MAC appeal number 721/2022, as well as cross objector in cross objection number 51/2022. Also heard Ms. R.D. Majumdar, learned counsel for the appellant in MAC appeal number 721, as well as respondent in the cross objection filed by the claimant. Learned counsel for both the sides have submitted that since disputed questions of facts as well as question of law raised by the insurance company is involved in this case, this may not be a fit case to be referred to mediation. Considering the submissions made by learned counsel for the parties, let this matter be listed for hearing on a date to be fixed by registry. It is otherwise fixed.
I'm praying for a date, lordship.
No, registry will fix. Today it is listed only whether it can be referred to mediation or not.
Item 52 from supplementary list.
In this case,
Supplementary list. Good.
not a fit case for mediation because the
Yes.
Lord, it is not a fit case for mediation because, my lord, the person has disappeared, my lord. And when a competent civil court has declared that he is dead, he could not be traced out for last 7 years, my lord. And they are claiming my lord, Mac appeal, my lord. Mac,
Who is the appellant?
the wife,
Is the wife.
wife, my lord. My lord, learned, tribunal below has dismissed the claim petition, my lord.
Oh, the question of law is involved.
Yes. Lord, it's not, maybe not fit case for mediation.
Okay.
As per title suit 5710, the claimant has filed one petition regarding this one. 7 years, since 7 years, the husband of the petitioner.
What has been outcome of the title suit? It is pending.
No.
It has been disposed.
So, and has been declared dead also. Husband has been declared dead.
But
in the order.
Dead, my lord, but
After 7 years.
it is not clear whether it is an accident or it is a murder, my lord.
It is an accident, lordship. And respondent number.
Court of law is declared involved, my lord. Not a fit
Third,
case for-
Mr. What is your name, Miss?
KLR Yanthan.
KLR Yangthang, learned counsel for the appellant. Also at Mr.
VK Burma, my lord.
VK Borwa, learned counsel for respondent number 2, as well as Miss P. Sutia, appearing for respondent number 1. After considering the issues involved in this appeal, as well as the submissions made by learned counsel for both sides, this court is of considered opinion that this is not a fit case to be referred to for mediation. Accordingly, otherwise it was ready for hearing.
No, yes, my lord, fit for hearing, my lord.
Accordingly, let this matter be listed for I see. Listed for hearing on a date to be fixed by registry.
And this one, item 16.
This is a statutory appeal, my lord. Notice will go, my lord. Regular first appeal.
Heard Mr. S. Das, learned counsel for the appellant. This appeal under section 96 of the Code of Civil Procedure has been, 1908, has been preferred by the appellant, Srimati Reena Saha, impugning the judgment and decree dated 15/6/2024, passed by the Court of Learned Civil Justice Senior Division, Borbetta, in the title suit number 54 of 2014, whereby the plaint filed by the present appellant was dismissed. The appeal is admitted. Let the notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondent by registered post with AD, by speed post within 7 days of the date of this order,
20th March.
returnable on 20th March.
This matter may be tagged with another RFA matter, which we have preferred against the allowing of their counterclaim matter.
20th March.
With RFA matter.
Just a minute. Let the record of the trial court be called for. Learned counsel for the appellant submits that the respondent has filed another. They have.
We have filed
The-
against
the-
the decree in their counterclaim.
The present appellant has also filed an appeal against the same impugned order, whereby the counterclaim filed by the respondent was allowed. And hence he prays for listing this appeal along with this said appeal. Which one is the
RFA 76 of 2025.
within bracket RFA 76 of 2025? List this matter along with the aforesaid appeal on the next date.
Highly obliged.
Item 17. Item number 17.
None appears for the applicant on call. List this matter in the next week on a date to be fixed by registry.
Item 18.
May I please arrest. My lord, this is regular first appeal, my lord, against the judgment and decree dated 11/11/2025 passed by the Lord Civil Judge Senior Division Lakhimpur. My lord, I am the plaintiff in this suit. My suit has been, my lord, dismissed. Against that, my lord, I have prepared another, my lord, RFA, my lord, and this appeal, my lord, against the counterclaim, my lord, because counterclaim has been decreed filed by the defendants. Only, my lord, considering the adverse positions. my lord.
Heard Mr. R. Sharma, learned counsel for the appellant. This appeal under section 96 of the Code of Civil Procedure, 1900 has been preferred by the appellants Shri Bhola Sahu and Shri Sohan Sahu alias Sohan Gupta, impugning the judgment and decree dated 11/11/2025 passed by the Court of Learned Civil Judge Senior Division Lakhimpur in title suit number 23/2022, whereby this is against counterclaim,
Against counterclaim.
whereby the counterclaim filed by the respondents was allowed. Stop. The appeal is admitted. Let the notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 18th of March. Let the records of the trial court be called for. Registry to take steps for requisitioning the records.
That this matter may be taken up, along with the, my lord, RFA 9 of 2026.
Let the record of RFA number 9 of 2026, which has been filed by the present appellant against dismissal of his suit, be tagged with this, be placed along with this appeal on the next date fixed.
I have a, my lord, IA, my lord, for stay of the, my lord, because counterclaim has been decreed, my lord.
We'll issue notice.
Because if they, my lord, proceed.
Stay, what stay?
Stay regarding the, allowing the counterclaim.
Counterclaim was allowed on what basis?
My lord, only adverse positions.
They are possessing.
Yes, they are claiming possessing.
That has been decreed.
But my lord, in the, my lord, counterclaim, there is no pleading as regards when. And
No,
what
what you want in this stay?
stay, my lord, stay regarding the death part, my lord.
Which part?
The judgment and decree allowing the counterclaim.
Any execution has been filed.
My lord, because they will, my lord, mutated their name because of this, my lord, considering this decree. Or lordship may granted the status quo.
No, in IA, issue notice. Same council name ke issue notice. The applicant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days of date of this order, returnable on 18th of March.
Because my lord, the suit has been dismissed, my lord. If the
Let the notice be served.
They are, my lord, entitled the right.
No, Mr. Sharma, let the notice be served. Thereafter, we will dismiss your interlocutory application. We are not dismissing it today. After service of notice, we will dismiss it.
May I crave indulgence?
After hearing it. Wait. Yes.
Lordship, may I crave indulgence of the lordship in item number 12, lordship.
My name may be recorded. It is sent for mediation, Lordship.
Item number 12, Ms.
Lordship,
M.
may-
Chaudhary.
Appearing for respond number 2.
M. Chaudhary appearing for respondent number. Naam to.
Respond number 2, Oriental Insurance.
Okay.
Must oblige, Lordship.
Orders, item 19.
Yeah, please, Lordship. My lord, due to oversight, my lord, we could not take, my lord, service of
Steps.
notice on respond number 3 and 4, my lord. So some time is needed, my lord. And reminder for TCR maybe. Issue, my lord.
Heard Ms. L. Sharma, learned counsel for the appellant, who prays for some more time for taking steps for issuance of notice on respondent number
3 and 4, my lord.
3 and 4. The prayer is allowed.
Justice service.
The appellant shall take steps for issuance of notice
Oh,
upon the
justice-
respondents by speed post,
Justice service. my lord.
along with by speed post within 7 days from the date of this order, returnable on 20th of March. Lamba date due. 30 April.
Oh, bless
The
you.
the appellant is also allowed to take steps for issuance of notice by dusty mode. Stop. If the appellant is able to serve the notice by dusty mode, it will submit an affidavit in compliance thereof on the next date fixed, list accordingly.
TCR may call for, my lord.
Let the records of the claims tribunal be called for. Registry shall take steps for requisitioning the records.
Oh, bless me, lord.
Item 20.
Lordship, we have to await service report here. In this case, for respondent number 2. 3, Lordship, the process server report is there, Lordship. He is served.
My lord, I have filed a lordship.
You are for?
I'm for the claim and lordship.
Okay.
In there, I also service is not complete, Lordship.
Lordship, I am the applicant, lordship, for drawing the money which has been deposited before the lordship.
Okay, no, let us first pass orders in the appeal. Heard Ms. R.D. Majumdar, learned counsel for the appellant. Also heard Mr. S. Ali. What is your name?
Yes, Ali, lordship.
S. Ali, appearing for respondent number?
1, lordship.
Respondent number 1.
In appeal, lordship.
Stop. On perusal of the office note,
There, they have not mentioned, Lordship, but at the back, Lordship, the service report is there. Registry should, in fact, verify that service report and present a fresh office note.
Lordship, I am the applicant, lordship.
just a minute.
This is in the appeal, the.
Service report is tagged.
Lordship, it is there, Lordship. And he has also filed one affidavit, Lordship, that person. Rohimuddin Barbuya.
Respondent number 3 is the lordship, diver lordship. My lord, my instruction is that lordship, he has given a written statement, lordship, to the his court lordship, saying that whatever the amount is given by the learned tribunal, that is right.
No, it is served. What is the name?
Rohimuddin. Lordship.
Rohimuddin, diver.
Barbuya.
Okay. On perusal of the report of the process server in respect of notice sent to respondent number 3 by usual mode, it appears that the notice has been duly served on the said respondent by the process server. The notice is accordingly held to be duly served on respondent number 3. Stop. As regards respondent number 2, though service report is awaited, however, the registry has furnished
blank tracking report, Lordship.
এইটো মাতিব লাগিব
Blank tracking report, how they can send that?
কোনে concerned section so superintendent along with the concerned the dealing assistant there এটা 15 চেম্বাৰত মাতিব লিখলে
The notice is accordingly held to be duly served with the respondent number 3. Respondent number 2, though service report is submitted, however, the registry has furnished
a postal track consignment report which appears to be blank. Registry is directed to furnish a legible postal track consignment report in respect of notice sent to respondent number 2 by speed post.
And also the usual process report may be called, Lordship, because steps were taken both ways.
Stop. The reminder may be issued for no, we will await. As regards the service report in respect of notices sent through usual mode, the comma await further. Let this matter be listed 18th of March. Where is the IA?
Lordship.
Yes.
The service is not, court had directed them to take steps. The service is not complete there also, Lordship.
Lordship,
Because,
One by one.
yes.
Let
because
her
of-
let her
Yes,
speak.
yes, yes, Lordship.
Then I'll sit, then you can start. The honorable court had asked them to take step, and because, Lordship, owner and driver are, especially owner is important part in, because we are challenging the judgment based on the evidence adduced by the company. So, Lordship, the court had directed steps to be taken. Till the steps are completed, Lordship, the release may not be allowed. That is my humble submission, and that is why the court asked them to take step on the all the respondents. They had served us, the other two respondents. And we had already,
Now, why they are necessary?
they are necessary, Lordship, because, Lordship, Lordship, he was driving he had a LMB license and he was driving a triple, Lordship.
No. As regards the disbursement of the amount which has been deposited.
Court judgment in, Lordship, Sonali Kolita is that where for disbursement, it is important that the owner should be present in the court. Today, since it was for service report, and tomorrow it can come, Lordship, I'll show that judgment. In the interlocutory application itself, that order was passed. That is why the notice was sent, Lordship.
But objection, you have paid the compensation. But the direction is to the insurance company.
Yes, that's why we filed the appeal.
What owner would say? But though notices have been issued, we have to wait for service of notice. But owner may not have
Yes,
any say.
yes, Lordship.
But, Lordship, the security part, because even if pay and recovery or something, Lordship, security part, the owner is essential. We indemnify.
Is it pay and recovery case?
Let me check, Lordship. No, that was not given. That is why we have filed the appeal, Lordship.
Yes.
My lord, I have filed the Lordship interlocutory application, my lord, to withdraw the amount which has been deposited to Lordship before the Lordship register of this court, Lordship. Lordship, kindly see my Lordship, first title in page Lordship 1, Lordship. I specifically made lordship statement. Lordship made it a lordship.
No, no. Now, whether notice is necessary. or not.
Lordship notice upon the lordship owner is not necessary because lordship.
But have you taken steps?
Lordship, I am the applicant.
Have you taken steps for issuance of?
No, lordship, my lord, because lordship, I am the applicant.
You have not taken steps.
Upon whom lordship, I have to take steps, since I am
They
an
have
applicant,
taken
I am the
steps.
applicant, lordship. Because the respondent, lordship, owner has been made respondent number 2 by the appellant, lordship. I am
Lordship,
not by
they
me,
have
lordship.
taken step, I suppose. Can I just peruse the I notice? They
Therefore,
have taken
lordship,
step.
my learned friend has made the owner of the vehicle as a respondent number 2. Therefore, she ought to have lordship take step upon the
No, no. In this interlocutory application,
lordship.
there is a direction. The common order was passed on the last date in MAC appeal as well as IA. Since IA has been filed by you,
Lordship.
you have to take steps against for issuance of notice on the opposite parties.
Since the lordship appellant has also taken step upon the respondent number 2, the owner of the.
Whether respondent number 2 has appeared.
Lordship not yet, lordship. My part is lordship to withdraw the amount interim lordship amount lordship. Lordship, lordship in respect of the needed of the owner of the vehicle, that may be lordship required in the hearing lordship, but in respect of lordship interlocutory application lordship, lordship no need for owner of the vehicle lordship. My lord, the young son of the claimant has been tied to lordship in front of hard lordship.
What is your ground in appeal?
Those are the grounds, lordship. And since the LCR has come, lordship, if lordship doesn't want to wait for the owner, hearing can be done any day.
No, no. We are on the question of whether to allow disbursement now or not.
No, lordship, they have to take step because already order is there. That order, if they do not file a review against that order, how that order can be changed, lordship? Already it was heard, lordship.
Lordship, earlier occasion, lordship, I wrongly heard lordship because I am the applicant lordship. I am not the appellant lordship. That I have to take step upon the owner
No,
of the.
but when there is an order of the court,
Yes, lordship, lordship.
you have to take steps.
Lordship, therefore, lordship, I
You
made
take steps by speed post. Heard Mr. S. Ali, learned counsel for the applicant. Also heard Ms. R.D. Majumdar, learned counsel for respondent number 2. It appears that by order dated, but you have stated on last occasion that.
Therefore, lordship, I made a submission before this honorable court that lordship, earlier occasion, lordship, I wrongly heard. Lordship, therefore, lordship, I made a submission that yes, I have taken step. It was a lordship wrongly heard by me, lordship.
Wrongly heard?
Yes, lordship, because lordship, I thought that I am an appellant.
No,
lordship.
no, you take steps because there is a direction.
In respect of lordship, a dual lordship. Lordship, that may be.
Because they are opposing.
Lordship.
And though on perusal of order dated 29/1/2026, it appears that the claimants learned counsel for the claimant submitted that had submitted on that day that steps for issuance of notice on respondent number 1 and 3 has been taken. However, today, learned counsel for the applicant / claimant has submitted that due to some miscommunication, a wrong submission was made by him. Stop. The claimant applicant is directed to take fresh steps for issuance of notice upon respondent number. Who is 1? Creative consultant.
Owner lordship.
Respondent number 1 and 3. By speed post within 7 days from the date of this order, returnable on Give a date. 13th,
So that may be given Lordship.
shorter date.
Lordship, I'll be out of station because I'll be going.
13th March.
13, I'll be there.
Let it be 13th of March. List accordingly.
Lordship, may I submit Lordship one day, Lordship, and number two, Lordship to.
Wait
dispose
for
of
that date.
the, Lordship interlocutory
Highly
application.
obliged.
Because Lordship,
On the submission which you are going to make on that day, reserve it for that day.
Lordship, obliged Lordship.
I'm sorry, my lord, I was not there on time, my lord, I wasn't.
Yes.
Here, my lord, earlier, lordship was placed to, my lord, reject the bail application, anticipated bail application of the petitioner, my lord.
Where is the rejection
On
order?
3 occasions, my lord, and lastly, lordship would kindly have a look at page 83, my lord.
On 3 times it was rejected.
Yes, my lord. Because here, my lord, if your lordship possibly may not remember also, my lord, here, my lord, there was no objection from the informant. I'm not on that. But since, my lord, the case has been registered under those sections, my lord, lordship was pleased to reject it, my lord. Although, my lord, the informant came before this honorable court and stated that, my lord, he has no objection, my lord. Now, my lord, on the merit of the case, lordship has already given that, my lord, that finding, my lord, in page 86, it is there, my lord. So, my lord, 86, para 9 and 10, my lord. Now, my lord, here,
Now whether police is still searching you?
that I have stated recently, my lord, they again came possibly maybe for filing of charge sheet. I've stated, my lord, in the petition, my lord.
Recently what?
But they search for the petitioner, my lord. Now, my lord, another aspect, my lord, that is there. Another aspect, my lord, I'm relying on the now recent, my lord, that judgment of the Honorable Apex Court, my lord, that 35(3) notice is a rule, my lord. That recently, around few days back, it has been passed, my lord. So here, if your lordship be the offense alleged, my lord, both BNS and the, my lord, the special act, my lord, here maximum punishment is 7 years, my lord. So, my lord, as a matter of rule, my lord, possibly because my understanding.
No, whether police is now searching
Yes,
you.
my lord, I've stated, my lord. I've stated, my lord. Because maybe for filing out charge sheet, my lord, that lordship.
Police can file charge sheet even without arresting
Yes,
you.
that is there.
If they have materials.
Now, page 15, that Roman 5 we have stated, my lord. And he is a government employee, my lord, around 58 years, 57 years, on the verge of attaining, my lord, on the verge of, my lord, that retirement, my lord. Now, my lord, since 35(3), earlier Ernest Kumar, thereafter until and recently, my lord, should I place it, my lord, and lordship possibly has gone through it, my lord? The recent one, my lord. Even it says, my lord, that after 30, as a rule, it must be given, my lord, that notice, and hereafter, if, my lord.
Yes, Mr. Sharma. Anything else?
My lord, that part is there, my lord, that 35(3) notice has not.
What is the status?
My friend.
I have to take instruction. Today it is come up for motion.
Motion, my lord.
Then we'll call for the case diary.
Lordship. Lordship.
When?
Lordship will kindly reflect that no new grounds has been taken.
These are not new grounds.
He has submitted category Lordship that he is not arguing on merit. So that may be observed, Lordship. Only this aspect may be gone through by your Lordship.
No. I have stated, my lord. Lordship will kindly say para 19, my lord. What are my new grounds? Lordship find, my lord, in abundance. Why I have given, my lord. My learned colleague may go through it, my lord.
I have already gone through Lordship.
Yes,
Let us discuss on the grounds of the Lordship.
Yes.
No, let us call for the case diary on next date. We are not giving any relief now.
Yes, Lordship.
Heard Mr. A. Chaudhary, learned counsel for the applicant, also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 482 of BNSS, 2023 has been made by the petitioner Shri Anil Chandranath, who is apprehending his arrest in connection with Morigao PS case number 352/2024 under section 75 within bracket 2/75 within bracket 78 within bracket 2 of BNSS, read with section 10/12 of the POCSO Act 2012. It is pertinent to note here that prior to this application, the petitioner had on 3 earlier occasions approached this court seeking anticipatory bail. And all the 3 occasions, the prayer for grant of anticipatory bail of the petitioner was rejected by this court. However, learned counsel for the petitioner submits that he has some new grounds, including a recent judgment of the apex court, which mandates issuance of notice under section 35 within bracket 3 of BNSS in cases where the offense prescribed is less than 7 years. Stop. Let the case diary be called for. When? Let this matter be listed. 11th of March,
Can it be preponed, my lord, little bit?
February. First, no, in the first week of March. 5th of March. Let this matter be listed.
My lord, notice to the informing POCSO matter.
Let also notice be issued to respondent number 2. The applicant shall take, the petitioner shall take steps for issuance of notice upon the respondent in pursuant to the prevailing notification of the registry in this regard. List accordingly.
Highly obliged, much.
Item 21.
May I please be my lord? Lordship, item number 17, Lordship, my name has not appeared in the position as caveator, Lordship, so that may kindly be. Appellant is absent. 17, Lordship.
Item number 17,
Yes.
Monune Losi dictation, Kodibo. Mr. A.R. Agarwal appears for caveator.
Caveator. And name may kindly be shown in the court list. That is not appeared.
The name of the Mr. A.R. Agarwal be reflected in the cause list as engaged counsel for the caveator
Clement.
henceforth.
Item 21 and 22. Item 21 and 22.
None appears for the petition. Applicant on call. Let this matter next week at the date. Let this matter be listed again on 25th of February.
Item 23.
May I please, your lordship? This is an application for condemnation of delay of 147 days, man. I don't know if there is the last order, man. The notice was served, but they are given time till today if they appear. Till today also nobody appeared, man.
Who is respondent number 2?
My lord, it is Metal Scrap Corporation Limited, my lord. A government company. He is not necessary party, my lord. Therefore, we have prayed on last occasion, name of that company we struck off, and accordingly prayer was allowed.
Whether they contested the suit.
No, my lord, though they have appeared, but they have not filed WS. Both the part 2 and 3.
Okay.
Here also, my lord, respondent number 1 notice was served long back, my lord, 8/12/2023, but till today nobody appeared. As per office note dated 8/12/23.
What is your ground?
My lord, at paragraph 3 and 4, I have stated that.
How much is the delay?
147 days, my lord.
What are the grounds?
May I read, my lord?
You may tell me.
Yes, my lord. Actually, the applicant met with an accident. Thereafter, my lord, after met with an accident, my lord sustained grievous injuries, and he is now basically on wheelchair. Therefore, my lord, he could not, and support staff also left. And in this period of Corona also, my lord, he could not take steps to file the appeal in time, which I have stated in paragraph 3, my lord.
Heard Mr. P.K. Roy,
S.K. Chakraborty.
S.K. Chakraborty, learned counsel for the applicant. None has appeared for respondent number 1 and 3. It appears that by order dated 21/1/2026, the service of notice upon respondent number 1 and 3 were held to be duly served. It also appears that name of the respondent number 2 was struck off from the cause title of this interlocutory application by the said order. Since today also, no one has appeared. This court intends to proceed ex parte against the respondents in this interlocutory application. We'll fix day after tomorrow.
Yes.
For ex parte hearing. Let this matter be listed again on
Well, can it be next week? We'll be out of state.
next week. 24th of February.
Of late.
Item 24.
May I please your lordship? Lordship, as per the office note dated 12/2/2026, respondent number, AD card of respondent number has been received back with signature of Bachadi, and respondent number 1 has not been received back,
Respondent number 1,
not received back, lordship. Yet to receive back, lordship.
when have you taken steps?
Lordship,
No office note. What is your name?
A.U. Ahmed on behalf of K. Bhattacharya.
Heard Mr. A.U. Ahmed, learned counsel for the appellant. Also heard Ms. M. Chaudhary, appearing for respondent number?
3, lordship.
Appearing for respondent number 3. On perusal of the office note dated 12/2/2026, it appears that the AD card sent along with the notices issued to the respondent number 2 has returned with signatures of who is Bachali?
Bachali, father of respondent number 2.
Bacha, within inverted comma, Bachali. Learned counsel for the appellant submits that Bachali is the father of the respondent number 2. In view of above, the notice issued to respondent number 2 is held to be duly served. The service report of notices issued to respondent number 1 has not yet returned back. The registry is directed to place the postal track consignment report of the notice issued to respondent number 1 on the next date fixed. Stop. It also appears that the records of the concerned MSC case has already been received by the registry. List this matter again on 9th of March.
Must apply, Your Lordship.
Item 25.
Lordship. Lordship, as per the office note dated 12/2/2026, Lordship respondent number 1, notice has been served, Lordship. And respondent number 2, addressee expired, Lordship.
So what is to be done in respect of respondent number 2?
Is substituted, to be substituted.
We will file an application. Let them take steps.
Lordship, I am appearing for respondent number 3.
Heard, Mr. What is the name?
Ayu Ahmed.
A.U. Ahmed, learned counsel for the appellant. Also heard Miss P. Bodhakur, learned counsel for respondent number
3, Your Lordship.
3. On perusal of the office note, it appears that the notice issued to respondent number 1 has been duly served, and notices issued to respondent number 2 could not be served as the addressee has expired. Learned counsel for the appellant submits that in view of the expiry of respondent number 2, the appellant may have to take steps, appropriate steps for substituting the legal heirs of respondent number 2. Hence, he seeks some time for the same. The prayer is allowed. Let this matter be listed on 11th of March.
Obliged.
Item 26.
My lord, in this case, service is complete, my lord, and the NCS have also been received. So let this matter be listed for hearing, my lord, in the month of May, first week of May. my lord.
Heard Mr. M. Alamgir, learned counsel for the appellant. Also heard Mr. A. Iqbal, learned counsel for all the respondents.
All the respondents except 1/4. 1/4 has expired, my lord, but she is duly represented by her brothers.
Who is representing?
1/4, my lord, is represented by her brothers, my lord. She did not have any issue. 1/1, 1/2, 1/3.
Learned counsel for the respondents. It is submitted at bar that this matter is ready for hearing and may be listed for hearing in the first week of May. The prayer is allowed. List accordingly.
Deeply obliged.
Item 27.
My lord, in this case, there was an order by your lordship's requisitioning the records. Now, since partly the execution is going on, and I think my humble submission would be, my lord, let scan copy of the record be transmitted to the honorable court. My lord. Because there were two parts. One was, my lord, quantification. That your lordship has said, no, you can't do by way of decree, since it was not the part of the original award, judgment. Therefore, my lord, let them transmit the, my lord, scan copy of the records. Otherwise, my lord, the execution case will come to a standstill.
Okay. What is your name?
Pujarani Chaudhary, representing on behalf of H.
Heard Miss P.R.
Chaudhary.
Chaudhary, learned counsel for the appellant.
Your Honor, I am representing on behalf of H. Gupta.
Reflected, appearing on behalf of Mr. H. Gupta, learned counsel for the appellant / applicant. Also, Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. R. J. Das, learned counsel for respondent number 1. Learned senior counsel for the respondent number 1 has submitted that the trial court records which was called for has not yet been received. He submits that since the execution proceeding is going on before the executing court and acquisition of trial court record at this stage may hamper the execution proceeding, hence he prays that instead of original record, the scanned copy of the trial court records may be requisitioned. The prayer is allowed. Let the scanned copy of the trial court records be called for instead of original records. Registry to take steps for requisitioning the records. List this matter after receipt of the scanned copy of the trial court records.
Deeply.
Item 31.
May I please your lordship? Lordship senior is at another court, maybe time.
What is the matter?
Condonation of delay, your lordship.
You have objection?
Lordship, on previous occasion, I have said that I would file an objection, but I can submit it verbally, your lordship.
Objecting to or conceding?
Objecting, lordship. Only my only submission is that, your lordship, they have submitted a medical document showing and explaining the delay. However,
How much delay is there?
127 days, your lordship. There is no explanation as to why, what happened within the 90 days, why they could not file it within the 90 days. The medical document that is annexed, your lordship, is after the expiry of the limitation period. That is the only objection.
Government is also there. We are allowing it. Heard, Mr. What is your name?
R. Mali.
R.
R. Mali on behalf of
R. Mali, appearing on behalf of Mr.
Surajit Das.
S. Das, learned counsel for the applicant. Also heard Mr. B.J. Mukherjee, learned counsel for the respondent, who submits that though on the last date he took time for filing written objection, however, he would instead make oral submission objecting to the prayer of the petitioner for condonation of delay of 147 days, 122 days in filing the connected testamentary appeal. Stop. This application under Section 5 of the Limitation Act has been filed by the petitioner Manajit Narjari, praying for condonation of delay of 122 days in preferring the connected testamentary appeal. Stop. In the said appeal, the present petitioner, as appellant, has impugned the judgment dated 8/8/2024, passed by the Court of London District Judge Sirang, whereby the title suit within bracket probate number 1 of 2022 filed by the present petitioner was dismissed. Learned counsel for the applicant has submitted that the applicant has, where the reasons are there,
Paragraph 3, your lordship.
the applicant had failed to approach the court by filing the connected testamentary appeal within the prescribed period of limitation, as he was suffering from ailments within brackets spondylitis, for which he could not, for which he was under medical treatment from 1/11/2024 to 10/3/2024. So he submits that in support of the said contention, the medical certificate to that effect has also been annexed by the applicant as Annexure 1. He submits that since the delay cause was not intentional and no malafide intention is there of the petitioner in causing delay, as it was the petitioner who was the plaintiff and whose suit was dismissed by the trial court. On the other hand, learned counsel for the opposite party respondent has submitted that though the medical documents for in respect of the ailments with which the petitioner was suffering has been submitted by the petitioner, however, he has not explained as to why within the prescribed limitation period of 90 days, the petitioner failed to approach the court. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record, including the medical documents annexed along with the application in support of the contentions made by the learned counsel for the petitioner. Stop. While considering an application for condonation of delay under Section 5 of the Limitation Act, the court has to take a justice-oriented approach as well as oriented approach. Stop. If the reasons shown by the applicant who has approached the court belatedly appears to be sufficient cause which prevented the applicant in approaching the court within the prescribed period of time, such a delay may be condoned. In the instant case, it appears that the petitioner has explained the reasons for which he had to approach the court belatedly. Stop. The said reasons, in the considered opinion of this court, may be regarded as sufficient cause which prevented him from approaching the court within prescribed period of limitation. Accordingly, the delay of 122 days in preferring the connected testamentary appeal is hereby condoned. The registry is directed to register the connected testamentary appeal and list the same for admission after a week on a date to be fixed by it. This interlocutory application is accordingly disposed of.
Item 33.
Lordships, so far as item number 30 and 32 are concerned, Lordship, the other side appellant took adjournment without my consent, Lordship. 30, item number 30 and 32, Lordship.
Okay, who took adjournment?
Counsel appearing Mr. A. Bhattacharya.
Okay.
So both the matters have been fixed. List, there is order, I think, Lordship, for listing the same after 2 weeks, Lordship.
Normally, during mentioning, I don't grant
Lordship.
if the counsel does not inform the other side. He might have submitted that he has informed you. Huh? Someone, Mr. P.S. Raja had appeared for defendant.
Lordship, my prayer is that date may be fixed.
No, that order has already been passed.
Date may be, otherwise it may not be listed within 6 months.
You make a mention about 30 and 31
Lordship may
on some other
fix the
day.
date, Lordship, after 2 weeks.
Not now, because orders have been passed.
I am the main contestant in these 2 cases.
No, you can make a mention tomorrow after informing the other side. You can make a mention, we'll pass orders, appropriate orders. In this matter,
I am appearing for.
My lord, there is a delay of 108 days, my lord, in filing the appeal, my lord.
you have objection?
I have no objection.
Your Lordship, I am appearing
I-
for respondent number 4.
You have
will be
objection?
Filing an objection, Your Lordship.
Okay, heard Mr. T. Kolita. When will you be filing?
Lordship, 3 weeks may be given.
Any objection?
My lord, I'm appealing for the applicant, my lord.
Time.
Time, David?
Heard Mr. T. Kolita, learned counsel for the applicant. Also heard Mr. M. Talukdar, learned counsel for respondent number 1 and 2.
1 and 2.
And Miss A. Biani, learned counsel for respondent number 4. Though learned counsel for respondent number 1 and 2 submits that he does not have any objection if the delay in filing the connected appeal is condoned. However, learned counsel for respondent number 4 seeks some time for filing written objection. The prayer is allowed. Let this matter be listed on 11th of March.
Obliged.
10:35.
This is a confirmation application, Lordship. My learned friend appeared for the sole respondent.
My lord,
You're objecting?
my client is willing to file a written objection to the condemnation petition. So I may be given 2 weeks time, my lord.
Heard Ms. R. Chaudhary, learned counsel for the applicant. Also heard Mr. A. R. Sikdar, learned counsel for the respondent. Only one respondent is there, sole respondent, who seeks 2 weeks time to file a written objection against the prayer for condonation of delay made by the applicant. The prayer is allowed. Let this matter be listed on 9th of March.
Obliged, Lordship.
Lovely.
36.
May please, Your Lordship. So I have for withdrawal of 50% deposit amount, which has been deposited by the appellant side in term of order dated.
You are opposing.
Yes, I have filed my objection.
You have filed.
Objection, Lordship. But in this case, he was a creditor's passenger.
Huh?
We had given evidence, his no premium was paid for covering him. The creditor's passenger in a tractor.
What is the status of the appeal? At what stage it is pending? Is it ready for hearing?
No, Lordship, LCR is not.
LCR not received. Lordship.
Not received.
How much was the
Lordship.
claim amount?
Claim on 13 lakh, Lordship.
13 lakh,
13 something,
13,000.
Lordship. 13 lakh. 13,30,500 lordship.
Subject to
Subject to
an
the-
indemnity bond, lordship.
Yes,
If you fail in appeal, you return back the money. That is
subject to deposition of bond lordship.
okay. Your for
One and one five, yeah. That's it.
Yes. Start off for appeal again.
heard
Yeah,
Mr.
it isn't step on. Five is there.
Okay.
Five is strict.
Yes, yes.
Heard Mr. B. Islam.
Lordship.
Heard Mr. B. Islam, learned counsel for the applicant. Also heard Mr. R. Goswami, learned counsel for the respondent insurance company in interlocutory application,
Yes.
as well as Mr.
I.K. Buragohain, Lordship.
I.K. Buragohai appearing for respondent number 5. This application, this interlocutory application has been filed by the applicants / claimants, praying for allowing them to withdraw the 50% of the awarded amount of rupees. What was the total amount?
So total amount of 30,500.
50% of the awarded amount.
They have already deposited 6,65,200.
That is rupees 6,65,150, which has been deposited by the appellant before the registry of this court in terms of order dated 28/5/2025, passed in IA civil number 2119/2024 in connection with the MAC appeal number 167/2024. When was the awarded amount? Date of award?
The order was 71 lordship, 2025.
Learned counsel for the petitioner. Applicant has submitted that the applicants were the claimants of in MAC MSC case number 1A, in MSC case number 827/2025, which was allowed by the trial court which was allowed by the Motor Accident Claims Tribunal number 1 Kamrup by its order dated 17/1/2025. However, due to filing of the connected appeal by the insurance company, they are unable to enjoy the fruit of their award. He submits that the applicant, who are the claimants, may be allowed to take the 50% of the awarded amount which has been deposited by the insurance company. Learned counsel for the insurance company submits that though learned counsel for the insurance company had filed a written objection against the said prayer. However, he fairly submits that if the applicants are ready to indemnify in the event of allowing of the connected appeal and return back the said amount, he does not have any objection. Stop. In view of the aforesaid submissions, as well as in view of the contentions made by the applicants in their interlocutory application, this interlocutory application is allowed. The registry is directed to disburse the 50% of the awarded amount, that is rupees 6,65,250, which has been deposited by insurance company before it, in terms of order dated 28/5/2025, passed in I number 2119/2024 slash 2024 in connected MAC appeal number 167 slash 2024 to the present applicants slash claimants after proper verification on their furnishing an indemnity bond to the tune of rupees 6,65,250, whereby, no, not whereby, undertaking that, giving an undertaking that they shall return back the said amount in the event the appeal filed by the insurance company is allowed and if they are required to do so. Stop. With above observation, this interlocutory application is disposed of.
Here, Lordship, motor accident claim to Kamrup Metro, Lordship. Metro.
Motor accident claims tribunal, Kamrup.
Item 47.
This IA is filed for condemnation of delay of 482 days in preferring a regular first appeal, my lord. I have mentioned the cause of delay in paragraph number 13 and 14, my lord. Actually, the file was handed over, my lord, to a council of this honorable court, my lord. And my lord, ultimately the file was returned, my lord, in the month of 6/11, my lord. I have annexed the documents, my lord, of the return of my brief, my lord. By the speed post, it was returned, my lord. I have annexed the envelope and the receipt to the postal receipt, my lord.
What was the date of the judgment?
4/4/24, my lord. It was an order, my lord, that suit is dismissed on delay, my lord. 4/4/24, my lord, and I had immediately handed over the brief, and the brief was returned on 6/11, page number 19, my lord. I have annexed the postal record, my lord, from the council, my lord. And then immediately I have filed the.
So the engaged counsel had retained the file.
Yes, in this period, my lord, and returned only on 6/11, my lord, on my request.
Okay. Any objection?
That delay was not properly explained, Lordship, that the envelope and the Lordship received indicate that they have sent back the file, Lordship. Only the address and the Lordship received.
Where is the envelope?
Page number 19, my lord.
19, Lordship.
19, my lord, and the text, my lord, I have typed the, my lord, postal, my lord, page number 17 and 18, my lord. 17 and 18. 17 and 18, my lord, my son's address.
What is this? Page number 19, what is this?
This is the envelope, my lord. I have the original also, my lord, with me, my lord.
No, by this envelope, what you intend to show?
My lord, this advocate, my lord, Iqbal Hussain Law Scholar, had returned back my brief, my lord, on 6/11.
In this envelope, brief was
Yes, my lord.
written.
Yes, my lord. I have requested him to have also the original, my lord, with me, my lord. The original envelope is also with me, my lord. Yeah. Speed post he has been returned.
Any other objection? We are allowing it. Heard Mr. MZ Kadir, learned counsel for the applicant. Also heard Ms. D. Burman, learned additional senior government advocate, appearing for respondent number 4, as well as Mr. D. Upamanyu, appearing for respondent number
1, 2, and 3.
1, 2, and 3. This interlocutory application has been filed by the applicant under section 5 of the Limitation Act for praying for condonation of delay of 482 days in preferring the connected first appeal, wherein the appellant has impugned the order dated 4/4/2024 passed by the Court of Learned Civil Judge Senior Division, Hailakandi, in title suit number 66/2023, whereby the suit of the appellant was dismissed on the ground of barred by limitation. Stop. Learned counsel for the applicant has submitted that the applicant is not responsible for the delay which has occurred in this case. He submits that after dismissal of the suit filed by the appellant on 4/4/2024, the brief of the case was returned by his earlier engaged counsel only on 6/11/2025. As such, he could not prefer the connected appeal within the prescribed period of limitation. On the other hand, learned additional senior government advocate for respondent number 4, as well as learned counsel for the other respondents, have opposed the prayer for condonation of delay on the ground that the applicant has not been able to properly explain the delay caused in filing the connected regular first appeal. Stop. I have considered the submissions made by learned counsel for both sides. It appears that the applicant has attributed the cause of delay to his earlier engaged counsel, who had returned the brief of the case to him belatedly. And in support of his submission, he has also produced the original envelope in which the brief was written, which shows that same was written to him on 6/11/2025. Stop. The cause, I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. The cause due to which the petitioner had approached this court by filing the connected regular first appeal belatedly, as stated in paragraph number 13 of the instant application, appears to be sufficient cause which had prevented the applicant in approaching the court for filing the connected appeal within prescribed period of limitation. Accordingly, the delay of 482 days in preferring the connected regular first appeal is hereby condoned. The registry is directed to register the connected regular first appeal and list the same for admission after a week on a date to be fixed by it. This interlocutory application is accordingly disposed of. Thirty 36 on item number 36 on main appeal on write the name of the counsel, list it for hearing after 2 weeks. 36 of the interlocutory application होते हैं dictation this हो. In main case there will be an order. How
Item 48.
Yes.
Delay for 204 days.
Delay. Will issue notice. Heard Mr. F. Z. Mazumdar, learned counsel for the applicant. This interlocutory application has been preferred under Order 41 within bracket Rule 3A of the Code of Civil Procedure, read with Section 5 of the Limitation Act, for condoning the delay of 204 days in preferring the connected MAC appeal. Stop. Issue notice to the respondents. The applicant shall take steps for issuance of notice. Only one respondent?
Only one, Lord.
Why? In the
Because in the appeal, there was only one respondent.
the applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Okay.
27.
On 27th of March.
Lordship.
Item 49.
My lord, limitation is barred by only 1 day, my lord. So delay may be condoned, my lord.
No, notice have to go.
The delay may condone, my lord, in admission, my lord.
Till how many days we can condone without issuing notice?
My lord,
What is the margin? Though limitation is, though the delay is only of 1 day,
Yes, ma'am.
but notice has to go.
Okay.
Heard Miss L. Sharma, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been filed by the appellant insurance company for condoning the delay of 1 day in preferring the connected appeal. Issue notice to the respondents. The applicant shall take steps
By usual.
for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, returnable on 25th of March.
Item 40.
May it please your lordship, in item number 39, our name has been wrongly mentioned, listed.
What is your name?
SK Begum and M Chaudhary.
It may be deleted, my lord.
What is your name?
SK Begum.
Miss S.K. Begum, Agor Kesot. Miss S.K. Begum, learned counsel submits that her name as well as name of Miss M. Chaudhary has been wrongly reflected as engaged counsel for the applicant in the cause list. Hence, she prays for a direction of the deletion of their name. The prayer is allowed. Registry is directed not to reflect the name of Miss M. Chaudhary and Miss S.K. Begum in this case in the cause list as engaged counsel of the appellant henceforth.
Item 40.
Though it is first time, my lord, and limitation is barred by only 28 days, my lord. They have appeared, already appeared, my lord.
You are,
For claimant respondent number 1 to 3.
you are not objecting.
No objection.
Heard Miss L. Sharma, learned counsel for the applicant insurance company. Also, Mr. M. Khan, learned counsel appearing for the claimant respondents. Stop. This application under Section 5 of the Limitation Act has been filed by the applicant insurance company, praying for how much delay?
28 days only, my lord.
Where have you mentioned?
In delay petition, my lord.
I number 8.
Yes.
I is not properly drafted.
That's all, my lord.
Where have you mentioned? In cause title, there is last line. Praying for condonation of delay of 28 days in preferring the connected appeal. Stop. Learned counsel for the claimant opposite party, Mr. M. Khan, does not raise any objection to the said prayer considering the grounds stated in the application. Stop. As the prayer for condonation of delay has not been opposed to by the claimant's respondent, as well as the grounds stated in the application are found to be sufficient ground which prevented the applicant in preferring the connected appeal within the prescribed period of limitation, the delay of 28 days in filing the connected appeal is hereby condoned, and this interlocutory application is disposed of. The registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by registry.
Well, my name may be reflected in the cost title in the.
The name of Mr. M. Khan may be reflected in the cause list as engaged counsel for claimant respondents.
Notice may go, my lord, on respondent number 4, 5, and 6.
No. Let it be listed.
Oh, bless.
41.
Please, Your Lordship. There is a delay of 58 days in the connected.
Heard Mr.
Yes, sure.
S. Sharma, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been filed by the applicant insurance company, praying for condonation of delay of 58 days in preferring the connected MAC appeal. Stop. Issue notice to the respondents.
The respondents are from Nagaur itself. We may be likely to take steps by usual process.
The applicant is directed to take steps for issuance of notice upon the respondents by usual process as well as by speed post within 7 days from the date of this order, returnable on 25th of March.
Item 42.
There is a delay of 19 days.
Same order, delay of 19 days.
The respondent number 2 is a minor. We may not be required to serve notice upon him. In the claim petition,
Who is representing the minor?
his mother.
His mother is a party.
Yes, Lordship. Respondent number 1 is the party. She is representing her son.
Same order. The notice to respondent number 2 may be sent to the respondent number 1 who is the mother of the respondent number 2, as respondent number 2 has been stated to be a minor. List accordingly.
Item 43.
May it please your lordship. Your lordship, this matter has come up for the first time. Delay of 23 days in filing the appeal.
Heard Ms. P. Bhattakur, learned counsel for the applicant. This interlocutory application has been filed by the applicant insurance company under Section 5 of the Limitation Act, praying for condonation of delay of how many days?
23 days.
23 days in preferring the connected MAC appeal. Stop. Let the notice be issued to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 27th March.
Obliged.
Item 44.
Please, your lordship. This is an application under Section 5 of the Limitation Act, where there is a delay of only 9 days. The grounds are stated.
What is your name?
My name is B.B. Gauhati.
B.B. Kakoti, same order. Date 27 March. Order same होगा, council का नाम अलग.
Item 45.
Please, your lordship. Also, considering the urgency in this case, lordship has to take steps within 10 days, lordship. And I have done it, lordship. But lordship, I cannot file the affidavit. There's a postal tracking report and also the justice report. Because the officer concerned, his father expired last week. Lordship may consider this and condone the delay, lordship. Because
No, where is the
yes, lordship,
service of notice?
yes, lordship, I cannot file the affidavit, but these are the dusty and the postal tracking report also. I'll file an affidavit if necessary, lordship. Lordship says so after the officer concerned, his father expired last week. He is not in station.
When will you file affidavit?
I will file the affidavit. In the meantime, lordship, there's an execution on 20th February, 20. Which is why, lordship, the court had appreciated, honorable court had appreciated my urgency, and it has come on 6th and 16th today. In 10 days, lordship, I have done it.
Then if there is an urgency, you should have filed the affidavit.
No, affidavit I cannot file because, lordship, officer concerned.
Somebody must be in charge of that absentee officer.
Legal, he only has the authority to sign it here. He's gone to Naharkate. If he's in Gauhati, I'd have probably got him to come and sign it. Naharkate, I couldn't manage it.
No, if some officer is absent, nobody is in charge of that person.
Small companies, one legal officer only, lordship. And his father died last week. But this lordship may keep this on record. I'll file an affidavit if necessary later on. But more based on my submissions, and this is I got the postal tracking report as well as the EA.
Okay.
That's it.
Heard Mr. R. Goswami, learned counsel for the applicant. On perusal of office note dated 10/2/2026, it appears that when is the date of execution?
20, lordship, this is the notice. 20th February 2002-2026. This lordship is the date notice.
No, on that day you appear before the executing court and show your cause
That I'll do, Lordship, but if stay is obtained, that will be, Lordship.
No, you
What?
have to file affidavit.
And file an affidavit only because of the exigency, Lordship, extreme exigency. The person's father died. He'll probably come at by the end of this week. He may probably. Lordship may keep this on record. I'll.
Yes.
file it.
क्या लिखा last? It appears that the notices issued to any of the respondent have not returned. Neither the appellant has taken any steps to file affidavit in compliance in respect of the notice directed to be served by the board. So Mr. R. Goswami, learned counsel for the applicant, submits that the notice by way of Dasti mode has been served on the claimant opposite party. However, since the concerned legal officer of the applicant insurance company had some urgency for which he is not in the station, the affidavit could not be filed. He, however, submits that the same shall be filed on the next date fixed. He also submits that the notice sent to the claimant by way of speed post has also been duly delivered to the claimant, and in support of the said submission, he has placed on record the postal track consignment report of the notice issued to the claimant. Is only one?
Claimant is Lordship only one. It's an injury claim.
Issued to the claimant. Said postal track consignment is marked as X and placed along with the case record. In view of the submissions made by learned counsel for the applicant, as well as in view of the postal track consignment report of the notice issued to respondent submitted by learned counsel for the applicant, the notice issued to the respondent claimant is held to be duly served. This application under Section 5 of the Limitation Act has been filed by the insurance company applicant, by the applicant insurance company, for paying for condonation of delay of 23 days in filing the connected MAC appeal. What is the reason?
Explain in para number 2, Lordship.
The applicant has explained the reasons in paragraph number 2 of the instant interlocutory application stop. After considering the reasons stated in the said paragraph, this court is of considered opinion that the delay caused, the reasons for delay, the reasons for the delay in approaching the court for filing the connected MAC appeal has been sufficiently explained. Accordingly, the prayer for condonation of delay is allowed, and the delay of 23 days in filing the connected MAC appeal is hereby condoned. This interlocutory application is accordingly disposed of. The registry is directed to list the connected MAC appeal.
Day after tomorrow.
And
What day is that?
on 19th.
19th. Okay.
On 19th of February. This interlocutory application is accordingly disposed.
Lordship, this will be kept on the record.
Yes, this I have marked and kept in the record. Because on the basis of
Well,
this,
that is already on record.
yes.
Obliged, Lordship. Deeply obliged.
Item 46 and 47.
May I please? Lordship, in item 46, there is a IA. IA is for withdrawal of the deposit amount. In 46,
You are,
for respondent.
Claimant,
Respondent,
do
claimant.
you have any objection?
No, my lord. Otherwise, case is ready for hearing, my lord, but TC had not come, my lord. Remind-
And how it is ready?
Yes, my lord. And otherwise ready, my lord.
Heard Mr. A. Sharma, learned counsel for the applicant slash claimant. Also heard Ms. L. Sharma, learned counsel for the respondent opposite party. This interlocutory application has been filed by the claimant applicant, filed by the applicant claimant slash claimant, praying for allowing the applicant to withdraw the 50% of the deposited amount of the deposited amount, that is rupees 2,50,987, comma, which has been deposited by the respondent slash appellant in connection with MAC appeal number 364/2022 on 23/5/2025 as a condition for stay of execution of the impugned judgment and award. It is submitted by learned counsel for the applicant that the present applicant was the claimant in the MAC case in which the impugned judgment was passed. He submits that though the impugned judgment was passed on 6/1/2016, however, comma, because of the present appeal, because of the filing of the connected appeal, he is unable to enjoy the fruits of the said judgment. Stop. It is not 50%.
25%, 25 to.
1,50,000 has to deposit in bank.
Less than 50%.
Yes, ma'am.
और 50% काट दीजिए. Learned counsel for the insurance company respondent has not opposed the prayer. Stop. Hence the same is allowed. The registry is directed to disburse the amount of rupees 2,50,000 987, which was deposited by the insurance company before the registry of this court on 23/5/2025 in connection with MAC appeal number 364/2020 to the present applicant slash claimant after proper verification. Stop. This interlocutory application is accordingly disposed of.
Reminder should go, my lord, for TCR, my lord.
Appeal heard, Mr. Him, what is your name?
Yes, Sharma.
Heard Mr. Ash. No, heard Miss L. Sharma, learned counsel for the appellant. Also heard Mr. A. Sharma, learned counsel for Claimant respondent. What is your name?
Your Lordship, my name is B. Thakuria, appealing on behalf of respondent number 3 for item number 47.
Also heard Ms. B. Thakuria appearing on behalf of respondent number 3. On perusal of the office note dated. It was sent for mediation.
Yes.
Yes, my lord.
It was
Mediation has failed. Office note. It appears that the trial court records I sent it.
Reminders should go, my lord. ना याद लिखा ना ऐसे.
It appears that the records of the trial court have been received and this appeal is ready for hearing. Accordingly, the registry to list this matter for hearing after 4 weeks.
Oblige me.
highly obliged.
Hearing item 48.
My lord, item number 48, fixed for 8-2, my lord. 8-2. Counsel for the.
At 2.
appellant is- Yes,
Okay.
oblige me.
Item 49.
Lordship. Koribone? Koribone?
Week 60.
It is tagged with 53. You want to do it today?
Please, Lordship. Lordship, here we have a related case of MFA 61 of 2022. Related case, so Lordship may kindly fix the date for hearing would take in week 61. Of
That is item 53, Lordship. 49 and 53 are arising out of the same accident. Supply list 53, Lordship.
Okay, what is the prayer now?
He wants another date, Lordship.
Lordship may kindly fix another date for hearing.
You have any objection?
No, Lordship, I am also not.
Okay.
feeling-
Heard Miss, what is your name?
R. Sahana.
Heard Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr. R.
R. Sahana.
R. Sahan.
Lordship, I write it.
What is the spelling?
SAHIINII. SAHIINII. R. Sahana.
HASI.
Write the name. Difficult.
Write down, right?
Learned counsel for the respondent who prays for an adjournment on the ground of personal difficulty. Learned counsel for the appellant does not oppose the prayer. He also submits that the instant appeal may be heard along with the MFA number 61/2022. The prayer is allowed. Let this appeal be listed when?
April, Lordship.
In the month of April on a date to be fixed by registry.
No, Lordship may fix that date, otherwise
Date.
registry won't.
On second,
When?
on second of April,
Second
or
already case.
28th April.
or 7th, 28.
28th April.
Lordship, Lordship,
28th April. Show the name of Mr. D. Nath.
Lordship.
It is shown, Lordship.
Yes.
It is
is
shown.
there, Lordship.
Earlier, AJ Sharma was there, so I
The
thought,
order sheet.
oh, order,
Lordship, Lordship.
Same order will be in item number 53.
item 53.
Lordship.
Hello, like. Apna phone number.
Item 50.
Lata Bajat Kuntul ঠিক হয়েছে?
May it please, Lordship.
Yes.
In this case, I am appealing for respond number 3, Lordship.
Who is for the appellant?
It was, I think it was by order, it was fixed today, Lordship. By order, they have brought it, Lordship.
We'll give a date.
Lordship.
Otherwise, we have to dismiss it for default, which we are not doing. None has appeared for appellant on call. Miss M. Chaudhary appears for respondent number 3. List this matter again for hearing on March on the on 25th of March.
25th of March. Yes, Lordship. It's a Wednesday. 25th is the Wednesday. 20, yes.
48 we'll take up at 2. Or you want to
Pass over, my lord.
an adjournment?
Yes, fine. He may not come, my lord, Mr. K.K. Bhattu.
Heard Miss 48. Heard Miss L. Sharma appearing on behalf of Mr. K.K. Bhattu. No. But Mr. M. Talukdar, you have any objection?
Must oblige, Lordship.
48.
48.
They are seeking adjournment.
They're seeking of adjournment, Lordship.
Any objection?
Day after tomorrow or any date, my lord.
Day after tomorrow, it may be fixed.
No problem.
Day after 2. No. Hearing day.
Hearing date.
Thursday.
Okay, ma'am.
Aji Monday no.
Thursday, okay, my lord.
Thursday.
19th. Heard Miss L. Sharma, learned counsel for the appellant. Also heard Mr. M. Talukdar, learned counsel for the appellant has sought an adjournment on the ground of personal difficulty of Mr. K.K. Bhatta, learned engaged counsel for the appellant. The prayer is not opposed to by the counsel for the respondent, hence same is allowed. Let this matter be listed on 19th of February.